G'day and welcome to another edition of the Aussie Ideas Man. I'm going to review the Aptera Owners Club interview with Heather Meeker, all about the Zaptera lawsuit that is pending. I'm going to try and make it very brief. I just want to hit on the main points, make my own points, and stay away from everything that really is irrelevant. As brief as I can be.
All right, welcome everyone. Today we are honored to be joined by Heather Meeker. Heather Meeker is she's a venture capitalist, intellectual property lawyer. So thank you so much, Heather, for joining us and kind of lending us your expertise. So can you explain to us what this lawsuit is?
Yeah, so the first thing to keep in mind about any lawsuit is that when you read the complaint, you're reading the plaintiff's version of the facts. The defendant gets a chance to answer the complaint and develop their version of the facts and so forth. So when we talk about what the facts are in this complaint, we're talking about the plaintiff's version of the facts. And they may be right, they may be wrong, they may be misleading, they may be spot on. You don't know until the lawsuit gets much further down the line. Right. But the complaint is essentially a patent infringement claim. There are other claims that are brought in the complaint, like trade secrets, interference with contract, unjust enrichment, and so forth. But the complaint spends most of the time talking about the patent infringement claim. And I think that's probably going to be the core. A patent is a right to exclude. And so if I have a patent on something, that means I can prevent someone else from doing something. And that something is usually make, use, sell, or import a product. It doesn't mean that I am able to produce any product at all. I don't have to have a product. All I have is this negative right to prevent people from doing something else. And so that leads to something that some people call patent trolling. The less pejorative name for it is a non-practicing entity. And that may be what this plaintiff is. I don't actually know. But it doesn't mean that the plaintiff has to have a product. It means that, at least as far as the complaint says, the defendant has a product that infringes the patent. And so the plaintiff can claim damages or ask for injunction, which means the court ordering the defendant to stop infringing the patents.
My first thought is that the complainant has a better chance, the defendant in this case, because if this is a patent dispute and the complainant holds the patent, then he's got the upper hand. It's as simple as that.
A company will start up, they'll get a patent or two, they'll fail, and then those assets get sold off when the company fails. The buyer becomes a non-practicing entity and then goes and sues whoever they can sue. Yeah, it's a really big problem.
So again, it looks like the complainant has the upper hand because he doesn't need to make anything, and trolling is being done because it's generally successful. If it was more unsuccessful, then the practice would soon cease. This indicates to me that Zaptera has the upper hand.
Okay, so it looks like, based on their complaint that we're reading here, that the Zaptera company they bought this out of something called an assignment for the benefit of creditors.
Right. So an assignment for the benefit of creditors is similar to a bankruptcy proceeding. What most people think of as bankruptcy proceeding in the U.S. is a federal court action. But there's a state equivalent called an assignment for benefit of creditors, which they've abbreviated ABC here. They are a little less complicated to do, and so sometimes people go through an ABC instead of going through federal bankruptcy. But it basically means that the debtor, the company, they can't pay their bills, they have to liquidate, And so they're assigning, meaning selling, their rights in order to get some money for their creditors. That's why it's called an assignment for benefit of creditors.
And I've been telling Bruce Baby and others that the first Aptera went bankrupt. This is saying that the only difference is that one is on the state level and the other's on the federal level, and they just give it a different name. Same horse, different jockey. Bankruptcy. That puts that one to bed.
I see. And so the two patents that are involved in this are these two patents right here, aerodynamic vehicle body and aerodynamic vehicle. Is that correct?
That's right. And one very interesting thing about this case is that these are design patents. So what most people think of as patents are the other category of patents, which is called a utility patent. A design patent is basically dependent on how the product looks. So this is very different from what most people think of as patents. And in fact, even lawyers who work in the patent area probably don't come across design patents all that often. They do, but it's much less common than a utility patent. And what that means is that when you ask, has the patent been infringed, the standards are quite different. So if you have a utility patent, and so let's say I've invented a better mousetrap and somebody else comes out with a mousetrap and I go, okay, that new mousetrap the other person did, it looks like it practices the inventions that are in my patent. Then we ask questions like, how does the product work? And is that the same as the invention that is claimed in the patent? And we would usually get an expert to testify, an expert in mousetraps, right? Somebody who is, as they say, skilled in the art to testify about it, and then you come to a decision about it. For a design patent, the standard is quite different. It's from the point of view of the ordinary observer. So it's not so much the purview of experts. It's more the purview of just an average person looking at one product and saying, hey, that looks like this design over there. So it's a different world. Also, design patents have a shorter term. So their term today is 15 years. When these patents were prosecuted, it was 14 years. And utility patents have a longer term, 20 years or sometimes a little bit more.
So, because this thing has not expired and it's a design patent, the claimant looks to have the upper hand again. The average person says that Aptera looks just like the EV, the machine in the patent. I think that's a strong upper hand if all it has to do is look alike.
The main thing that people use in order to defend things about the way a product looks is what we call trade dress. So there's a whole body of law, trademark law, that has to do with the source or origin of goods. So if I have a product and the design of it suggests that it comes from me, and the example people always give is like the Coke bottle with the like wavy shape and everything, then I can prevent other people from selling those products on the basis of trade dress. And that's probably easier because I don't have to go and I can file a trade dress application much more easily. And patent prosecution is pretty expensive. So there's this overlap between these two areas. And so I would say you see fewer design patents because there's another body of law that often deals with these issues. If you have trade dress, that means you're protecting your own products. And so there's not this trolling aspect to it. Also, the way the product looks has to be evocative of a particular source for the product. And that's not true with design patents. It's just, do they look the same? The ordinary observer doesn't have to think, oh, this design is associated with this specific source. So it is a little bit different, but they do overlap in quite a few respects.
In our previous discussion, I sent you some pictures of things that look similar to this? Okay, well, I think we should maybe go down to the pictures in this complaint. Okay, yeah, so here we go.
Yeah, these are very interesting to look at. The plaintiff has put side by side
Right.
the designs from the patents and the current, I guess, the Aptera vehicle that I don't remember exactly what the status of that is. Maybe it's in the design stage.
Yeah, they're in the stage where they finished design and they're trying to make the testing vehicles to validate the vehicle, basically. And so this design has now been finalized, essentially. And they have these side-by-side pictures, which do look similar.
They do look similar. And then the big question here, I think, is how much of that similarity is functional? So utility patents protect function. Design patents do not protect function. So, never the twain shall meet, right?
Okay.
So anything about the design that is functional in nature would not be protected. And you can imagine, I mean, these are being called aerodynamic designs, right?
Yes.
So anything about them that is necessarily the way it is because of aerodynamics, that would be more of a functional aspect to it and might not be protected by the design. So that's where the complexity is going to come in here. Like how much of this is driven by function and how much of it is like the artistic or aesthetic nature of the design.
I see. So if Aptera, the company, states or makes the case that their vehicle looks like this because of function, then that can be used as a defense against this design patent?
It might. Now, this is where this case might get a little complicated because there is this notion in patent law that called assignor estoppel. Okay, so then we have to talk a little bit about what happened in this case.
Okay, yeah.
So, sorry to derail you a little.
No.
But what happened, at least according to the complaint, is that the original iteration of the Aptera company, which I think was Aptera Inc.
Yes.
It closed down. It did an assignment of benefit of creditors, and it sold its patents to apparently the plaintiffs. I think there's some lack of clarity about that, but
right, there's some dispute about that, possibly.
Yeah. But that's what the complaint says, right? So the plaintiffs buy these patents from the old Aptera company. And then Aptera of today is a new company that was set up to succeed the old one.
Yes.
Now, the problem is that there's this notion of assignor estoppel, and here's what it is. If I sell you a patent and then you sue me for infringement based on that patent, I can't claim the patent is invalid, or I might have significant limitations on what I can do there because I took the position that the patent was valid when I sold it to you.
I see.
Now, this case is way more complicated because it's not the same entity. It is some of the same people. And you may have noticed that the complaint actually, it purports to sue individuals as well as the company. And I may be reading between the lines. That might be because they want to prepare for an assignor estoppel argument because the people who are actually being sued are some of the inventors on the patent.
Right.
So as an inventor or owner of the patent, you have trouble claiming that the patent is invalid because you once basically said to the government, right? And then again to the person you sold it to, this is IP that I own and it's valid.
There is another reason why the complainant has an upper hand. It is a strong point that this patent is valid. But I'll digress here. They talk about it later, but I'll talk about it now. When we see videos from Aptera, all about how they started up and the whole story, it's always Steve Fambro had the first idea and started building the design. And then he got Chris Anthony in because he was expert in composites. So he was just brought in for the body. And they brought in Jason Hill because he was actually an interior designer and did also mess around with the exterior. I guess the way they put it was to make it look prettier. That's all. This is what I've remembered from seeing all their historical videos. In a nutshell, the design was Steve Fambro's. Steve Fambro is not mentioned in this list at all, which is surprising. What's also surprising is so many people that are not known are mentioned as inventors. It's just mind-boggling. But one stands out, Paul Wilbur. Paul Wilbur, in the history that they give, in all the videos that they've made, Paul Wilbur was the Detroit expert that they called in rather late. And this is in Aptera 1. I'm not talking about the second version of Aptera. In the first version of Aptera, Paul Wilbur was brought in rather late. They already had the 2E design. They had that design that's on the patent. And Paul Wilbur decided that he wanted a four-wheel vehicle of a pretty much different design. He wanted to give it four wheels and I think even make it a five-seater. But in any case, it's all weird. We've got no Steve Fambro, and in their history, he's the designer. We've got Jason Hill. He was brought in later to make it look prettier on the outside and to design the interior, also to be appealing to the public. And then we have 7 or 8 other complete unknowns as designers that were never mentioned by Aptera. And to top it off, we have Paul Wilbur, the evil Detroit expert who wanted to design something very different. How on earth did he get named as an inventor of the design that is in this patent? The mind boggles. But so far, the complainant is looking very strong because it's a patent that has not expired. They don't have to make anything. It only has to look the same, and they've pretty well made that clear with the side-by-side pictures. Most other things are irrelevant. Aptera's trying to defend it on points of the wrong sort of patent, on points of a utility patent and not a design patent.
So the defendant here might have more trouble than most defendants would have claiming that the patent is invalid.
I'll stop here because the expert just ratified what I have been saying. She's in favour of the claimant having the upper hand.
What they would have trouble arguing is that what is claimed in the patent is not valid. So there's probably some wiggle room in there.
What kind of damages can they sue for? Because this company has not sold a product yet.
Well, of course, if the company had sold products, it would be a more interesting damages argument.
Yeah.
But I mean, I don't know what damages arguments the plaintiff is going to make, but they might claim that the value of the company is part of the damages or something like that. You know, they've raised some money, I guess.
Yes.
And the value of damages for patent infringement, the core thing is what we call a reasonable royalty.
Okay.
And so that's kind of market driven, and obviously there might not be a very useful set of market comparables for this.
Yes.
So there would be a lot of argument about what the damages are in a case like this, and it would go back and forth. And you know, the defendants would say it's zero, and the plaintiffs would say it's $1 zillion. That's just the way it always works.
Right. But the fact that they haven't actually sold anything does not protect them necessarily. There are other damages.
No, because a patent governs the right to make, use, and sell and import. But you don't have to have sold a product in order to be infringing of a patent.
Again, the complainant will have the upper hand because while the defendants might be saying their net worth is zero, they've been saying all along that they're worth about, I think it was 800 million. They have made claims that their company is worth roughly $800 million. They've also claimed that they've raised over $135 million in crowdfunding. So there's a lot of money there. A lot of it might have been spent, but damages are awarded on the value, and they have been broadcasting an $800 million ballpark value. It's going to be hard to then go to the courts and say our value is nothing.
This is the letter that they sent on July 28th, 2022 to Aptera. And they basically told them, hey, you guys are infringing. Okay, this is my understanding of the letter after reading it. They said, hey, you're infringing on our patent. You need to contact us so we can talk about you giving us royalties or something.
Right.
And then Aptera responds to them with this letter, which basically says, from what I understand, don't talk to us. You haven't proven that you even own this thing. So until you can prove to us that you even own this thing, because as far as we understand, Idea Labs owns this thing and you have no standing here. So just stop talking to us.
This brings out another dimension to the whole matter. Aptera telling Zaptera the patent in question. But they don't say we own the patent. They say Idealab owns the patent, which is absolutely bizarre because Idealab has nothing to do with them. If you ask N. Bruce Nelson, he will tell you that Aptera Inc. and Aptera Corp. are worlds apart, nothing to do with each other. And so, if Idealab had anything to do with the first Aptera, it has nothing to do with the second Aptera. Aptera can't claim to own it. And then to say Idealab still owns it is ridiculous because they're only setting themselves up for Idealab to take over the lawsuit. Idealab, if they own that patent, they can sue Aptera. Why would a company do something so idiotic as to turn around and say, well, we're not even going to talk to you because somebody else other than us owns the patent? It's crazy.
They might say, even if it infringes, there should be no damages. There would be many different arguments.
Right, many layers of defense on this. Yeah, because in here, they give them this exhibit that claims that Idea Labs owns it.
Another thought came to mind. Aptera has always been giving its story. I've always said there's 2 or 3 of them and we don't know who's lying, but the main flow of the story that I've been getting over the 3 years that I've been interested is that somebody died and Fambro and Anthony bought the intellectual property from the widow of the dead person. Later on, I discovered that this dead person was an employee of John Way who was given the job of setting up Zaptera. It hardly matters. The point is, Aptera themselves tell the story that they purchased the patents from the widow. If that story is true, then why aren't they saying we own the patents, not Idealab still owns the patents? There's something fishy going on there.
Idea Lab is a company that was very interesting. It developed a whole lot of stuff during the internet boom, and so it's interesting that they bought or purportedly bought these because they mostly did web stuff.
And so then this document date is more recent than that. And they're saying that in this one, the assignee is Zaptera.
Yeah, so it's possible the patents were sold on to someone else.
Can you tell us like what you think may happen in this case? Or is that just...
Well, what usually happens in patent cases is that you end up paying some royalties. The important thing to understand about patent lawsuits is that they're about money.
Mm-hmm.
And so you dispose of them with money. And some of them really go to court and get big settlements. So I don't know anything about this plaintiff. And so, but a lawyer who was defending this case, the first thing they would do is do some research on the plaintiff.
I see. But most of them do end up with some settlement, whether it be small or large.
Yeah, that very much so.
I'll just interject once more. It's not really right on point, which is what I wanted to be. But looking at the name, we've got assigners there. In the middle of those names, one of the inventors was Marquis McCammon. And McCammon is a rare name, and yet their media manager is Chris McCammon, I think. I don't know whether the spelling's exactly the same, but I'm just wondering if there's some reason why he got given the job at such a young age. Was there what do they call it? Nepotism. Was there some nepotism going on there? Is Chris McCammon related to Marquis McCammon? And that's why he was given the job. They pretend it's because he was good at open pilot, but you never know with Aptera because they lie a lot and they have invented stories many times over. There's nothing left in everything else that's been discussed here because it's got nothing to do with the lawsuit. So I'll end here and just say that's all from me. Bye for now. Stay safe.